Thank you ever so much, Honourable Chair. Coming back to the section, just 4678(1), subsection 2, A and B, where it describes the approval of the Lieutenant Governor and Council is not required for the Minister to enter into an agreement under subsection 1 in the prescribed circumstances or in respect of a prescribed class of agreement. So my understanding, the Minister, through you, Honourable Chair, recently said that the type of agreements that he or she or whoever the Minister will be can enter into are controlled by Cabinet. But, Honourable Chair, we have no indication as to what prescribed circumstances are. We have no indication as to what prescribed class of agreements are. It could be, and I seek confirmation from the Minister, that a prescribed class of agreements could be any agreement to extract natural gas from the Montney region in British Columbia and export it anywhere in Asia. That's one possible interpretation. Under the prescribed circumstances, that the Minister has the time to do so. Essentially, this would grant the Minister, we have no sense of this. So is what I just said precluded from that, or what constraints are being placed on the Minister to enter into these agreements without consulting, without the need for the Premier, without the need for Cabinet, without the need for anyone, obviously, except the proponent, to know about what the agreement is, because this set of prescribed circumstances and agreements is so large and vague as it could include anything, Honourable Chair.
Minister.
Thanks, Honourable Chair. Through the member opposite, it gives the Lieutenant Governor and Council in prescribed circumstances in respect to prescribed classes agreements to allow the Minister to execute them. Those will be prescribed in regulation through Lieutenant and Governing Council, not arbitrarily by the Minister.
Member.
Honourable Chair, and I guess that's my point, is that I reiterate what I said earlier, is that in light of the fact that this government is so desperate to sign agreements with now one company, it's I guess given up on a number of others, that there is a lack of trust. There's a lack of trust that this section is not going to be anything more than prescribed class of agreements is with Petronas, for example, or with any company involved in the Montney play and that wants to sell gas to Asia. So there is a great deal of uncertainty with this, and you know, this amendment does simply not instill confidence in British Columbians that the government actually has any sense of direction or actual clue, Honourable Chair, clue as to what they're doing. They're making it up as they go along, Honourable Chair, moving it from a generational to now, as my friend from Nanaimo, North Cowichan points, a multi-generational sellout in desperate attempt to try to land a company. So let me just follow up with a direct question here. If, Honourable Chair, the Minister signs an agreement under subsection 2, and then after giving it to the Lieutenant Governor and Council, now it's signed, the Lieutenant Governor and Council receive this, and they then determine that they don't like it, that the Minister overstepped his or her bounds. And then my question is, what ability does the Lieutenant Governor and Council have to overturn an agreement that was signed by a minister under section 78(1) and bracket 2?
Minister.
Well, thanks, Honourable Chair, and through to the member opposite. I know that the NDP and the independents in this House don't support liquefied natural gas as an industry for the future of British Columbia. I know that. I know the member's clearly after that in his mind, and that's fine. But if the member will think about the legislation that allows regulations to be developed that specify the circumstances or describe the types of agreements that the minister can enter into. Don't get to write the agreements. Lieutenant Governor and Council actually prescribes that in regulation, and by the way, Honourable Member, every week the decisions by Lieutenant Governor and Council and regulations are published. So that information in and around the agreements would be published, and the minister could only execute under those terms. If he went outside those terms, because of the regulation being in place, it wouldn't be a legally enforceable agreement.
Thank you, Honourable Chair. And with respect, this has nothing to do about being against or for natural gas. This has to do with economic folly and irresponsible promises by this government in an election campaign that they cannot fulfill. And here we see desperation in legislation. We see one after another as they so desperately try to land a single contract. So, Honourable Chair, the reality is, I'm going to read this again. I have read this legislation. It says as follows. The approval of the Lieutenant Governor and Council is not required for the Minister to enter into an agreement under subsection 1 in the prescribed circumstances or in respect to a prescribed class of agreements. It doesn't say in respect to an agreement that has been reached and agreed to by Cabinet already. It says in a prescribed circumstances or a prescribed class of agreements, which is incredibly vague, no matter how you interpret that, Honourable Chair. So again, to the Minister, if he believes that these circumstances or agreements are really curtail or constrain what he is able to sign, why doesn't he tell us what they are? Why doesn't he table here today what is actually meant by prescribed circumstances or prescribed class of agreements? Because right now it can be anything, Honourable Chair. Will the Minister table examples of what these are?
Minister.
Thanks, Honourable Chair, and I'll reiterate it. I do know the member opposite doesn't support liquefied natural gas as a new industry for British Columbia, but even in that case, this is actually a piece of the legislation that allows for regulations to be developed that specify the circumstances that the minister could actually enter into and sign an agreement on behalf of the province of British Columbia. The regulation is a law, Honourable Member. The minister has to follow that law in those prescribed circumstances and in the respect of the prescribed class of agreements. He has to do that because that's defined in regulation. The regulation is developed when legislation is passed.
Member.
Well, and again, Honourable Chair, to correct the record, I have never said I am against liquefied natural gas. In fact, if you go back to estimates, you will see that I've been arguing strongly for promoting a domestic sector use, including the use of liquefied natural gas in our ferry systems in British Columbia, long before the government actually came up with that direction and idea. So this is not about liquefied natural gas. This is about irresponsible economic outlook, that the government is going in with no financial underscoring. They seem to be the only ones in the world that believe this is going to play out, and they're desperate to do so. So coming back to the question, Honourable Chair, the reality is, as the minister would like us to believe, it is that somehow he's going to be constrained in entering into these agreements, that the regulations will be developed after the fact. There is no trust on this file anymore, Honourable Chair. So there is no trust. The government is simply not trusted to be acting in the best will of the people on this particular file, because we've seen time after time after time broken promises, changing legislation. We bring in an act, LNG Act. We then completely change the LNG Tax Act only a few months later. And it's for this reason that I have a second amendment that I wish to put here to actually add another check in place. And this is on the order papers, Honourable Chair. It's adding a section 8, bracket 8, bracket to 78. So it's 78.1.1, bracket 8, bracket, that says the following. The Lieutenant Governor and Council may, without penalty, pull out of an agreement entered into under subsection 2 within 6 months of the time at which the Minister provided the Lieutenant Governor and Council with the full text of the agreement. Honourable Chair, the reason why I'm doing this is I don't trust the Minister. The opposition doesn't trust the Minister. The people of BC don't trust the Minister. International companies don't trust the Minister. The Minister has no trust on this file, Honourable Chair.